Welcome everyone. Great to have you here today as we begin a new era under a Labor government. There's
Lewis,
a lot we have to get through.
I might just stop you there. I think you're reading from the wrong script.
You're right, that script was written a week ago.
It was, and ladies and gentlemen, thank you for tuning in. For those of you that bothered, thinking that we might not have a lot to talk about today, but we do. It's our special election analysis. The Labor Party did have a very elaborate scheme of changes that they were proposing from the workplace relations perspective. You might think that the coalition government did not have very much to do in that space, but in fact we've got a bit to talk about today, don't we, Lewis?
Yeah, that's right. There's a range of things that we've identified where we're likely to see changes and continuing developments in the industrial front. So it's probably timely because most employers out there have really been focused on the Labor Party agenda because I think most pundits expected a different outcome at the election. So I'm not too sure how much businesses are across the coalition platform and the things we might see from the union movement over the next 3 years.
Now, before we get into our material, I might just quickly let everyone know that there's apologies forthcoming from our CEO, Nigel Ward, who had hoped to be with us today, but he is in Canberra, incidentally, on important business for a client that was urgent, and sends his apologies to all of our listeners and viewers. So, what's happened? Just from a numbers perspective today, I note that there are, I think, 76 seats in the House of Representatives for the coalition, and a range of seats for Labor and the Greens. I think Labor in the 60s, the high 60s, and it looks like the coalition will have probably 77 seats by the looks of it. So does that mean they've got a mandate to do what we're about to talk about? I don't know, and I don't think so, but you'll see from some of the topics we're going to talk about today that whilst the Labor government had some elaborate plans, the coalition government had some really interesting, important measures that were going to be put in place for workers that were vulnerable workers, migrant workers, and also some other changes to protect transient workers and workers who have uncertain work like casuals. They're going to need crossbench support if they're going to get legislation through, because it looks like in the Senate the coalition will not have majority. They'll have sort of around the mid-30s, and that's not enough. I think they need the high 30s to get through. Labor will have a range of seats in the mid to high 20s in the Senate, and the Greens will have 9, as we're currently told, and there's a range of other independents. One Nation has 1, Australian Conservatives have 1, and the like. But that brings us to the more interesting stuff. The first thing, I think, Lewis, we want to talk about is, well, what's the reaction from the unions and the ALP going to be?
Yeah, so I think we're likely to see a two-stage response to the election over the weekend. I think the first thing we'll likely see is perhaps a subdued level of activity over the next 3 months. I mean, you have to remember that particularly on the ACT youth front, they have been pursuing a change the rules campaign for 2 years now, minimum. And the Labor Party, in particular their shadow employment spokesman, Brendan O'Connor, has been out in force for at least 12 months, prosecuting the case for change, speeches at various seminars, conferences, anywhere they could get to effectively a microphone and a platform. The Labor Party and the ACTU were running a very focused and comprehensive campaign on change. And I think there's going to be a level of exhaustion. There's going to be a level of inward focus for a while. There's going to be, at the political level, the ALP are going to be looking at their leadership. We already know that Bill Shorten stood down from the leadership post, which means there's going to be a level of internal leadership debate. And equally the ACTU, they're going to have a level of introspection. I'm not suggesting there's going to be any leadership change or anything at the ACTU level, but that doesn't mean there won't be a period of introspection, a lull in activity. And so for those employers that are currently involved in enterprise bargaining, they might find that the level of opposition they face or the level of industrial disruption they face might not be what could otherwise have been the case. I think there'll be a lull.
Initially.
But then you talk about what, though, is the longer term impact? What's the environment likely to look like 2019 onwards, or late 2019 onwards, I should say? I think there's probably 3 or 4 different types of focuses we're going to see. absolutely the first thing that the union movement can do is ramp up focus on individual employer compliance issues. Continue the story about wage theft that they've prosecuted quite loudly for the last 2 years, saying there's employers out there paying improperly, not following the minimum award obligations they should, and that this is unacceptable. And that had a level of success over the last 3 years. We saw the Liberal Party introduce more significant penalties through its Vulnerable Workers Bill. I think the stories about franchisees, I think the stories about any employer not complying with their obligations is likely to be one that continues. And if you are not paying the right rates, if you're not doing the right thing, absolutely, I think you can expect PR campaigns on social media, you can expect prosecutions by the union movement, and effectively Sally McManus and the ACTU standing up saying the system's not working, here's why, we've got employers not doing the right thing.
I think that's right, Lewis, and I think we have seen Sally McManus be a very fierce advocate for those positions that they've advanced over the last 2 years. And unless she decides she's going to have a political career, which is possible, but it may not be in the next 6 to 12 months, and it may not even be in the next term, we will see. While she is at the helm of the ACTU, they will not be easing off. If anything, as Lewis has just said, they're going to be ramping up. There might be a lull for 3 months to 6 months as they realign themselves, both the ALP and the ACTU, and then they're going to focus again on individual employers and all of those things that Lewis talked about.
There's just a couple of other things in relation to what I think we'll see. There was a big part of the Labor Party platform related to equal remuneration for workers, and we had a lot of talk about the childcare subsidy, which was intended to apply. Bill Shorten had announced increasing childcare wages by a few dollars an hour in relation to that sector. That's no longer available at the parliamentary level. That doesn't mean it goes away. What it means is that what we're likely to see is that kind of case being prosecuted in the Fair Work Commission. And in the Fair Work Commission right now, what we're likely to see is effectively the IEU, the Independent Education Union, together with the United Voice, pushing for a wide range of changes in the childcare industry, which will see significant wage increases based on the fact that they're saying remuneration is not equal across the genders. Industries that are predominantly female-based are not seeing the same type of wage outcomes. The IEU case, as I understand it, is pushing for claims of up to 60% higher wages in that industry at the award level. And so that is going to unfold in the next few months, but that won't be the last ERO case. I think what you'll see is because these wage changes that the union movement had sought to achieve parliamentarily aren't available, I think we're going to see it in the Commission.
Well, I think that's right, Lewis, and I think we need to be mindful also, and I think the unions need to be mindful also, that while there are no substantial changes in relation to the Commission or the Fair Work Act around awards and around equal remuneration, that employers can also pursue cases. And they are currently pursuing cases around efficiencies and around, and they have historically around penalty rates and the like. Those types of applications are still available to employers under the current scheme. So whilst the unions will agitate those claims, employers will continue to agitate the counterclaims.
I think that's right. And I think on the union front, so we've mentioned the ERO, we've mentioned the fact that it's likely that we may see other types of compliance focus from them. I think the final two areas from the union is absolutely this living wage argument's not going away. The living wage, I suppose, campaign that was pursued by Bill Shorten and the Labor Party, that was being pursued by the ACTU well before it became an issue at the political level. We're going to see the ACTU bringing a very substantive argument to the Fair Work Commission as part of the annual wage review. They are saying that the minimum wage should not be set in the way it currently is. The minimum wage should be set at 60% of the median Australian wage. And absolutely that's not going away. We're likely to see determinations on that in the coming months. And if it's not to their liking, it'll come back next year. So I think they'll continue to pursue that. And the last thing is, and this is, don't want to scare employers too much, but I suspect over the next 3 years, the notion of the award wage settings themselves, the way that the pay rates are structured and the value of the rate compared to the work, or what we call in industrial relations the work value. That's another target area likely. And we may see work value cases start to emerge. One or two have already started to burgeon in the current award review. And these are all mechanisms and levers that can be pulled entirely outside of the parliamentary level, entirely outside of statutory change. So whilst you might say, well, the Labor Party agenda won't be progressed in 3 years, that's a large number of types of issues that we're going to see ventilated in the Commission just by the union movement. And that's before we get to, I suppose, the Liberal Party's response and the employer movement response.
I think, one of the things that people expect is that the LNP won't do a lot, the government won't do a lot around industrial relations unless there's a case pursued for change. And I think the unions and other organisations have demonstrated that if they approach this correctly and agitate in a way that's appropriate and acceptable to the government, they can get results. And we're going to talk about some of those things like the migrant workforce task. And one of the things around the Liberal Party platform, if I can say, the industrial platform, which wasn't much, but there were a number of choice things there, is that they're going to retain the ABCC. So the Australian Building and Construction Commission is going to be retained. The Labor Party platform had been proposing to remove that altogether, and that will stay. So there are lots of employers out there very happy about that. The ABCC regulates not just unions but also employers and how they behave in the building and construction space. And it's been a much maligned organisation by the unions over the years, but it's been there for a while, disappeared, and now it's come back, but it's here to stay at least for the next 3 years.
Yeah, and the Registered Organisations Commission's the same thing. They were brought in by the Liberal Party in response to the Royal Commission on Trade Unions. There's a lot more oversight of both employer organisations and employee organisations. That's likely to stay. And just on that case for change point, I think that's right. If you look at what happened over the last 3 years, there were occasions where the statute was changed. We had new rules in relation to bargaining, changes made to if there were technical errors or any kind of minor errors in relation to enterprise agreement approval processes or voting processes, that can now be subject to a level of discretion from the Fair Work Commission, not previously the case. Same with notice of representational rights in bargaining. So where employers have demonstrated there is a real issue here that needs resolving, the Liberal Party will listen, but they're not going to just run off on a flight of fancy. They're going to want to see cogent, evidence-based reasoning to support a change. And if that's there, then we might get some level of reform.
And it's a bit of a shame because there's a lot that can be done with the Fair Work Act where there are inadvertent errors made by the previous Labor government in bringing that legislation into place. We know that because the explanatory memorandum itself actually doesn't align up with the Act in many places. So there is a case for change in a range of spots, but because of the Howard government changes back in 2007, prior to them losing government at that time to the Rudd government, the LNP government since has been reticent to do anything because they're worried about that. And it's been very difficult with an opposition that hasn't been willing to play ball.
Yeah. So speaking of which, there were a number of bills previously tabled in the last Parliament which did not make it through into legislation. And it is possible that a number of those bills will come back in one form or another. The first is the casual conversion bill. So the Liberal government proposed to insert into the Fair Work Act itself a right for casual employees to convert to permanency after a 12-month period if they had regular and systematic hours. And that right of conversion can only be negated if there were reasonable business grounds to refuse it. That legislation didn't get up, largely because it had some interesting wording around what a casual may or may not be or how it's defined, and that didn't get the support of the crossbench or Labor Party. So that's one thing that might come back.
Well, this is good policy, and it's difficult to see why this shouldn't get up if it is re-agitated through the Parliament, because at the moment we've only got award-covered employees where those awards provide an entitlement for an employee to either apply or be offered casual conversion, where they can convert from a casual to a full-time or a part-time position. So this is good policy. And I think given that we're at the front end of a 3-year term, this has much greater chance of getting up at this point if they re-agitate it. Yep.
The other thing, as Joe mentioned earlier, there's an increased focus on protections for migrant workers. So there was some level of grey, if you like, in relation to how the Fair Work Act applies to a transient migrant workforce that might only be in the country for a brief period of time. To what extent do the Fair Work Act entitlements apply? To what extent do Fair Work small claims procedures apply to a migrant workforce literally temporarily in the country? There's a desire to try and improve protections around that. And that's something that hasn't quite been progressed to the point of being passed in Parliament, but might come back.
Yeah. They're also looking at whether or not they bolster some criminal offences around the behaviour of registered organisations and whether or not persons who are holding office in those registered organisations are a fit and proper person. So it is one might say that this is a bit of clamping down on unions, but the way this has operated is very much like the Royal Commission, focused on unions, but the laws that have come out of those inquiries have actually resulted in an oversight of both employer associations and unions. So there's been an even Stevens there approach.
Then there's some interesting dialogue,
It's very interesting.
that the Liberal Party's talked about, which hasn't been previously been tabled as bills in Parliament, but the kind of dialogue and rhetoric we've heard from them over the last 12 months about where they might move. And the first of those areas relates to labour hire licensing.
Which is interesting because the Labor government had proposed a federal labour hire licensing scheme. We have one in Queensland. Victoria are following suit. South Australia had followed suit for a while but have pulled out. New South Wales hasn't proposed to introduce one, but the other states and territories have been looking at it. So it's very interesting that the federal coalition were looking at this particular space in connection with migrant workers specifically, but with a focus on particular high-risk industries. And those high-risk industries were the meat industry, cleaning, security and horticultural industries as well, where they do find that there are a lot of vulnerable workers who are migrant workers in those industries, might require protection from unscrupulous employers.
Yeah, and I think it is interesting because just for the benefit of listeners out there who are engaging labour hire workers in Queensland and Vic, very important that you're aware that there are now licensing regimes in place, which means regardless of where you are based, if you're engaging a labour hire worker in Queensland or Victoria and the worker is not from a licensed provider, you yourself can be subject to penalties and there are fines that will apply to employers engaging unlicensed labour hire providers. So that's the regime already in place in 2 states. It was the Labor Party platform. It's now is part of the Liberal Party platform to have licensing in some industries. But importantly, what they are not talking about, which is what the Labor opposition were talking about, is this notion that labour hire employees should be paid site rates or host employer rates. So there isn't any discussion that if you engage a labour hire provider, you have to pay them the same, or those employees the same amount as you pay your own. But will they need to be licensed? Perhaps.
We'll find out. The next one's a really interesting one, and it's one that is going to be very difficult for a coalition government that doesn't have both houses to resolve. And that is this misalignment between the various obligations under work health and safety laws, under bullying laws, under discrimination laws, and unfair dismissal generally. And sexual harassment, of course, and discrimination. So how they all interact, and Lewis and I have talked about this in the past, and we've talked about different cases and different areas of law. But generally speaking, there is not an alignment of all of those obligations. You've got your health and safety obligations, which are very serious and very significant. Then you've got your discrimination laws, which sit in a misalignment to those laws, and then you've got your unfair dismissal laws, which again sit in misalignment to those. And there are some employers that over the years have been very, very disappointed to have dismissed someone who has engaged in either inappropriate conduct from a sexual harassment perspective, or from a discrimination perspective, or from a health and safety perspective in particular, and have proceeded with dismissal only to find that they have a finding against them in the Fair Work Commission of unfair dismissal.
Yeah, precisely, and it is something that the Liberal Party talked about as recently as April this year, about wanting to try and amend the unfair dismissal laws so as to try and ensure that an employer that complies with their obligations under one law is not then hit with liability under another. And there's a variety of ways that might happen. If you take sexual harassment, they could look to redefine the definition of serious misconduct under the regulations. Now, that's something that doesn't necessarily need Parliament to approve. The Minister could do that with the Governor-General's assent. So there's a few different ways they could attack that, but the reality is that I think there's noises being made by employers that's not going away about, well, how do I ensure I provide a discrimination that I know is free from harassment, discrimination, or a safe workplace if I can't proceed to discipline with some level of firmness and surety around these issues, and it might come back up. The other one, and this is the
bugbear.
I was going to say I toyed with the notion of bugbear. It's certainly a can of worms. It's the enterprise agreement approval process.
Yes.
I
think a bit of history is worthwhile giving here at this point, Lewis. And I think
please enlighten us.
when you look at the history of what's occurred here, is the Fair Work Act provides for a very prescriptive process of making an enterprise agreement, from the bargaining, from the commencement of bargaining right through until the approval process, including the Better Off Overall test. Now, the Better Off Overall test, the detail of that is perhaps not quite specific in the Act. It talks about being better off overall. But what we have seen historically is where the Commission once was quite happy to take an agreement that was supported by both employers and a union and approve that on the basis that they could be confident that it passed to the boot because everyone else seemed to say that it did. We're now in a world where we have the member assist team at the Fair Work Commission and various members going through with a fine-tooth comb, picking every single clause and comparing that to the award and any external document that is referred to in that agreement. And what that has meant is that it's a painstaking process. Now, in defence of the member assist team and the members of the Fair Work Commission, part of the reason that they currently operate that way is because there've been a range of full court decisions and federal court decisions where they have been taken to task for failing to meet their obligations under the Fair Work Act in the approval process. So there is a very detailed, pedantic assessment process that they go through in the Fair Work Commission, and with good reason, as I said that. So what are they looking at now?
Yeah, well, I do want to come to that, but you've just now kind of
opened up a can of worms.
Stirred my interest a little, and I think wanting to be diplomatic about this, but there is a real issue, and I think your defence of the Fair Work Commission in this respect is somewhat warranted, in that we have a federal court that is applying at the moment a level of technical assessment and analysis of what is meant to be a very effectively fluid, kind of simple, fair approval process. The whole point of the Fair Work Act and the way it's meant to operate, if you look at its objects, it talks about fair, just, efficient process. And so particularly when employers go to the Commission with an EA that's supported by the union, supported by the employers, voted up overwhelmingly by the workforce, some of those matters could allow for a less prescriptive line-by-line forensic microscope approach.
Well, the Act also talks about not being caught up in technicalities either.
That's right. But you get to the federal court, and if you run a technical argument, it gets a wide level of attraction from the federal court justices who don't necessarily practice day-to-day in this same area. And we're seeing then effectively handcuffs coming back down to the Commission. So part of the message that the Liberal Party needs to take out of this is, well, what's happening at the federal court level? Do we need employment-specific judicial members that actually have been in the area, understand the area, and now can apply a level of judicial decision-making with the benefit of the background. So that's just my little two cents.
It's not a new thing either. I mean, we did have a specialist industrial court in New South Wales for many years, many decades. It's probably no surprise we're having that discussion again.
So I suppose that's still part of the problem. In terms of the solution, well, the Liberal Party did say in its policy, one of the few things that were in there was we're looking at removing unnecessary red tape from the approval process. And I think that's code word for fixing up the current issues employers are having around getting EAs approved. There's still quite long waiting periods. Experience varies from case to case, but you can still be waiting many months to have an EA approved.
You can. The National Inquiry into Sexual Harassment, this is a really interesting point, and I understand the drivers for what's currently coming out of that inquiry and what's being said out of the inquiry, but it does give cause to some concern about how the system might operate.
Yeah, I think, like you say, absolutely the Sex Discrimination Commission needs to be applauded for conducting what has been a really wide-ranging inquiry into the prevalence of sexual harassment in workplaces, looking at causes, looking very much at workplace culture, and rather than just say, what do the laws say, why is it that workplaces are having these incidences of sexual harassment? So a very wide-ranging review has been undertaken. What's interesting is some of the I suppose, the little avenues in which the inquiry has taken course. And one of the most interesting is this notion of employers entering into non-disclosure agreements with employees in relation to claims of this nature. There's been a wide range of views expressed. Some submissions to the inquiry have said that non-disclosure agreements are inappropriate for this type of matter, that employers should not be able to silence victims of sexual harassment. And you can see, Joe, on the one hand, there's a fair degree of merit behind that concern. But I take it there's a competing view as well that might have some...
Yeah, look, Lewis, my concern is that whilst I see, and you and I have both seen cases where there has been sexual harassment, and that you could see why an individual might want to retain the right to be able to go public about that or speak to someone else about it. But you can also see, we see a lot of claims over the years we've been doing this, where the reason money is paid and an agreement is entered into is because it's a commercial outcome. It's not because anyone has been sexually harassed. And in those circumstances, and with that regime available where you can settle a matter and you can have someone who feels aggrieved but may not have been sexually harassed, they may have been subject to some adverse treatment, you can see the work that those agreements have to do is good work, because it means that individual gets some money, they go away, the employer gets some comfort that they're paying some money in exchange for the complaint going away. Now, if you're being righteous about it, you might say, well, this person should be able to be heard, they should have their case and have their day in court. And I think that's okay. I think if someone wants to have their day in court, they can. You and I both know they can have their day in court.
And this is the problem, though. Not every complainant wants to have their day in court.
That's it.
They don't necessarily want to have their name published. And you only have to look at the recent defamation case involving Jeffrey Rush, where a lot of media was surrounded the actual victim in that case, in the sense that the matter got out of her hands because an article was published in the Daily Telegraph. Jeffrey Rush said it's defamatory and he pursued his legal entitlement to challenge that and ultimately was successful. But she didn't want to be involved in a court proceeding. She didn't want to have her name published, didn't want to have a video footage of her taken or photos, etc. And the reality is she was unnecessarily and unwittingly brought into a very large-scale litigation because of a litigation that was ongoing. And some complainants, whilst they might want redress, they might want disciplinary action taken against the offender, they might want some form of compensation, they don't necessarily want their names being made public. And that is more likely if we enter into a scenario where all of these claims could be litigated, and employers are less likely to settle then.
That's right.
If they don't have the protection of the NDA.
I mean, what we both know, not just when it comes to sexual harassment cases, but when it comes to unfair dismissal cases, when it comes to discrimination cases, when it comes to bullying cases, that sometimes people are just happy to take a little bit of money and go away. And the very a very large portion of claims are misconceived, or they're confused individuals who feel aggrieved. And so if you get to this circumstance where you take away the ability for an employer to have that go away commercially with the ability to have it confidential, it's not worth much to the employers who are paying that go away money. And then they might say, well, why would I pay this money? Let's just have our day in court. And what you're going to have is a range of people who think that they were sexually harassed or think they were bullied or feel aggrieved about something that in actual fact, legally speaking, does not meet the threshold. And they've gone through court and spent all their money on that because the employer wasn't in a position to give them a commercial deal. So I think it does take away an ability for parties to reach a sensible outcome and a commercial outcome in many cases. So I'm a little bit concerned about that. I mean, it'll be great business for lawyers because there'll be lots of people pumping their fist in the air, saying, let's run this case. So there'll be a boom in legal fees. A halfway process might be whereby a court has some role in perhaps approving a settlement with a confidentiality arrangement. That might be a
That's right. And it's really interesting here, the Law Council has come out and it has echoed a number of the concerns Joe had about banning non-disclosure agreements entirely. But even the Law Council said that there might be some approach that could be adopted to ensure that settlement agreements are ethically drafted. So there might be some way of finding a middle ground whereby the settlements aren't too onerous or aren't, I suppose clearly unfair in one way or another, but do provide the protections that employers usually seek, which is a release from further claims and confidentiality. So anyway, that's all going to unfold as part of the national inquiry. That's not the only issue. That's just one of the many issues being debated. But I think we'll see a lot of really helpful stuff come out of it in terms of particularly some of the findings about workforce culture that we'll report back on once the findings are clear.
Stay tuned.
Yes.
So next 3 years, industrial relations, from the Fair Work Commission's perspective, what do you think?
So I think, just take another sip of my tea. I think it's easy to think that because the Labor Party didn't succeed in its reform agenda in IR, there won't be reform. If you look at the last 3 years, we have had a significant range of movement in a large array of areas, and indeed in cases where our firm's been prominently involved. So in 2014, just before the current government, I think it was then the Turnbull government, took power, we had annual leave test case come in relation to an ability to cash out annual leave being introduced in all modern awards, an ability to direct employees to take annual leave introduced in all modern awards, an ability for employees to take annual leave in advance introduced into all modern awards. That change came through the Fair Work Commission, not legislatively. Same with penalty rates. We've heard a lot about penalty rates. That was a creature of the Fair Work Commission. The employer movement pioneered by the Australian Chamber and also other industrial associations brought a case. Our firm acted for the Australian Chamber in that matter, and we brought an evidence-based case to say the Sunday penalty rate and the public holiday penalty rate in the services sector was too high. And the Fair Work Commission, after a huge number of hearing days and hundreds of witnesses, came to the conclusion that they agreed. Now, again, that change is going through the Fair Work Commission. Beyond that, we then had new provisions in relation to part-time and casual employment, new minimum engagement clauses, casual conversion introduced. Now, that was a union claim. Unpaid domestic violence leave. That has come in as a result of a claim brought by the ACTU in the Fair Work Commission. And now, family-friendly employment provisions. They are also being introduced as a result of a successful claim by the ACTU. Now, all of these claims, I might add, ABLA acting for the Australian Chamber. And so you can't say there hasn't been a lot that's gone on in the Commission over the last 3 years. And right now, our firm is continuing to act in a number of common claims. annualised wage arrangements in awards are still under the microscope. There have been changes to abandonment of employment provisions that have now gone out of the awards. There is a common claim pertaining to payment of wages and how the obligation to pay arises and when payments are due. That is still live. And more recently, the overtime entitlements for casuals are coming under the specific microscope of the Fair Work Commission. In this case, not even at the behest of any party, at the behest of the Commission itself. So that's just what's happened and what's going on. The changes that we've seen are likely to be enshrined now because we're going to have a period of 3 further years without, say, intervention from the Labor Party. So I think by the time there's a new government, the penalty rates case will be long finished, long moved on from that, the changes implemented. That pattern of industrial litigation is likely to continue. And so I suppose the question is, in what form?
Well,
We've got a few ideas.
What's interesting about that, Lewis, is that even though we did see through the ACTU campaign, Change the Rules campaign, that they were pointing at the government and saying that, well, you're responsible for penalty rates being lost, and in actual fact, it was employer associations that did that through the Fair Work Commission. The Fair Work Commission agreed there was a case for that and agreed that penalty rates would be reduced over a period marginally. There was a marginal reduction. And in that year, that was last year, they then also handed down, I think, the largest increase in about 10 years for an annual wage increase, which is interesting. So take a little bit away from penalty rates, but take away with one hand and give with the other the annual increase to everyone. And then we're also talking now about the Fair Work Commission, which has been empowered to do this since the Act came into play in 2009 and in full force from the 1st of January 2010, to, of its own motion, make various changes, including overtime for casuals. So it is interesting that we've had a lot happen in the last term, the last 2 terms really, under a Liberal government. And as Lewis says, we're going to see this start to be more enshrined. We've also got a government, it hasn't been consistent in terms of leadership, but we've had a coalition government over the last 6 years that does have a habit of looking whether or not this stuff should not only be enshrined in a common sense, but whether or not that should make its way into the NES. So we might also see a bit of that over the coming 3 years.
Yeah, I think where the case for change has been made in the Fair Work Act, that there is a tendency to then apply it. Now, in terms of cases over the next 3 years, I think there are a few things on the horizon. We've already mentioned the equal remuneration order proceedings currently live. I think we will continue to see equal remuneration claims by the union movement. A particularly interesting one is the New South Wales Business Chamber. It's brought in a claim for a new category of employment. Now, we're actually acting in that matter.
I think it was your idea.
and effectively what we are looking to do is say where there are long-term casual employees, that the federal court is now telling employers, well, if they're long-term, they have regular set of engagements, they might actually not be casual, they might be permanent, and you might have obligations in terms of back paid leave entitlements, unpaid overtime amounts potentially. In order to address this exposure that's arisen, the New South Wales Business Chamber is proposing a new form of flexible ongoing employment whereby casuals can be rostered the way they have been traditionally, the same type of rostering arrangements, their hours can change, there's no obligation to come in, the work is offered just as if someone is ordinarily a casual. But instead of receiving the 25% casual loading, the employee receives a 10% loading and in exchange will accrue annual leave, paid personal leave, they'll have ability to access redundancy and notice of termination entitlements, unfair dismissal entitlements. And so what that would see is effectively an enshrining of the regular forms of casual engagement that are already out there in modern society. We know that the federal court says the way that casuals are currently being employed is a problem. The federal court's saying, I don't care that you've paid a casual loading, they might still be permanent. And this is a way of saying, okay, well, we've got to live with that decision. If we're not going to get legislative change, let's provide employers with an ability to engage employees in a flexible manner, the way they currently are, but accrue leave for them so that there isn't this exposure to back pay. And obviously the consequences of that is that the loading goes from 25% to 10%.
There's a bit that's been done around casuals. We had the government introduce the casual set-off regulation, which was opposed by the ALP. I think Doug Cameron raised an objection in the Senate, and that's been postponed, I think, until Parliament kicks off again. So at that point, that's an ability for employers to set off their casual loading or to help employers try and argue that they can set off the casual loading against a claim for unpaid leave if a person later says, I should have been employed as a permanent employee, ongoing employee, full-time or part-time, instead of a casual. We're yet to see how that'll play out in court if it actually makes it to a court. But as Lewis says, we've had a range of things around casuals and watch this space for the permaflexi application because I think that's really important.
Yes, and I suppose in terms of the battleground in the Commission for the next 3 years, the other thing that we are watching is, and we mentioned this before, the notion of work value, but how all the award rates are aligned. There's some discussion going on by way of an initial statement issued, I think, at the Commission level about asking about how these wage rates are set and aligned. And the reality is, unfortunately, if you actually look at all the wages, they were all pegged to a certain point about a decade ago, and they have come out of whack. So the wage rates have effectively been condensed over time due to the way that some of the wage increase works. So they're no longer at the same relativity that they once were. Now, that presents fertile ground for someone to come in and say, well, I think these should all change the way they operate. And I suspect we're going to hear some noise about that. So that's something we're very actively watching for, because if that is a discussion that happens, we need to be very clear, representing employers, that their voices about how it should look like are heard, because it could have some significant impacts in terms of the actual dollar amounts paid to employees.
Well, one of the issues here is gender pay gap, and that's not going away. That's an issue that's going to be one that the coalition is going to have to deal with even in this next 3-year term. It's not off in the distance. It's not something that will one day resolve. It's an issue that's currently being played out in the Commission through the equal remuneration case. And we're involved in that, of course. And it will not be an issue that will go away. So I think we might see a little bit more from the government around the gender pay gap. And then we've also seen, as Lewis has already talked a little bit about, the Fair Work Commission doing this review, as he says, about the awards, and a reassessment about how those rates are paid. We've actually seen a bit of movement in terms of award scopage as well. So the scope of awards, who they cover, because there are many people out there that think in award land that think everyone's covered by an award. And as we know, not everyone's covered by an award, and that means someone like poor old Lewis and I are subject to the minimum wage. So should there be a solicitor's award? But I don't know. Someone has tried to get one up over the years for lawyers. Maybe we're not deserving of one. But I think that's another thing we need to watch in terms of the scope of awards, or new awards might be something that come onto the radar, because if the ACTU don't have a new piece of legislation to work with, they might start looking about, well, how can we start making things a nicer place?
Yeah, precisely. And I think, Joe, the other organisation, and I think we may have some questions I see popping up on your radar that we might need to come to. But whilst Joe kind of assesses the questions coming in and hopefully pops them out, we cannot forget the role of the Fair Work Ombudsman in this current industrial regime. It was conceived by John Howard as a child of the work choices legislation. It was actually called the Office of Workplace Services. It has been grown by successive Liberal and Labor governments, year after year, budget after budget, term after term, and they are everywhere. I mean, their inspectors are in every metro area. They're in regional areas. They're conducting audit trails through the middle belt of New South Wales. Well, we've got their harvest audit campaign. And the FWO has been, I think it's one of the few areas that Labor and Liberal agree on, is unanimous support for the role of the FWO, unanimous increases in funding for the FWO to enable them to continue to pursue underpayment claims and ensure employers are not effectively being remiss in their payment obligations. And that's not going to stop.
Yeah, and look, they do, from year to year, they do sometimes have a contraction of funding in particular areas. So but generally we've seen overall growth year on year. I think just coming back to for example, the Harvest campaign that they had, they recovered over $1 million in wages in that Harvest campaign. And they also team up with other government agencies. The Migration Agency, that in some cases the Federal Police. You'll find in jurisdictions where they have labour hire licensing regimes like Queensland, even those agencies, the Department of Industrial Relations in this case in Queensland, get involved. So you see a collaboration of agencies. They're very coordinated, they're very slick, and they do a pretty good job.
Yeah, and I think the message on the Ombudsman front to employers that are listening is the best way of addressing a matter is to ensure you are, and I think it's two things. One is proactive and the other is cooperative. And if you are proactive, that is when a matter comes in, don't sit on it. You've got to do some calculations about whether you've underpaid or not. Don't put in the too hard basket. So get on top of it early and be seen to be cooperative with the Ombudsman. Respond to their requests for information. Consider the issues they've raised. That cooperative does not mean just put up the white flag and say, okay, whatever you say, we'll do it. That's not necessarily the case. If you disagree with a calculation or with a particular entitlement, absolutely you can raise it. But what you want to be seen to be doing is considering the matter seriously, taking advice on the matter to ensure that your interpretation is correct, and engaging with them regularly to let you know what you're doing, how you're reviewing any particular complaint. Because where we see employers fall down and end up the subject of prosecution is where they have been lax, where they've almost been recalcitrant in their dealings with the Ombudsman. It's just about proactive engagement, in my view.
Look, it is, and it does bring me to some of the things that this government, or certainly the coalition government, has done the last 6 years, including the Vulnerable Workers Bill, where they made certain offences subject to 10 times the penalties that were under the Act at the time, and so that was $63,000 per breach. That went up to $630,000 per breach, or $12,600 for individuals, or $126,000 for individuals involved in that. Now, that was focused at the time on the franchise regime and around the country, but also some other penalties in relation to other offences. The Fair Work Ombudsman was also given a range of bolstered powers around compelling individuals to give evidence or attend interviews and answer questions, save for legal professional privilege being one of the only saving graces in that process for individuals worried about being exposed personally. And you will find individuals in these businesses that are exposed personally, but always get advice if you have any doubt about it. And I think where the Ombudsman's concerned, it's a good idea to get advice if you receive a notice. Yeah, don't sit on it, as Lewis says. Get some advice. The other thing is that the coalition government also been talking again about expanding the Fair Work Ombudsman's powers so that they mirror the ACCC, for example, and their ability to gather evidence. So watch that space as well in terms of further expansion of powers. So, it's interesting today we've talked about a whole range of things that the coalition government are going to do, even though everyone thought they didn't have a policy or a platform from an industrial perspective. And they certainly do have a whole range of things they're already looking at. Some of them have some synergies with a lot of the Labor Party platforms, just not on the same scale. Now, just going to some of our questions, Lewis, one of the questions is, haven't ERO claims already been heard and rejected in relation to early childhood educated teacher wages on the grounds of old stats and other seasons? In one respect, yes.
Yeah, thank you for the question. So just to paint the ERO picture, there were two claims. One was by the United Voice in relation to childcare workers. One was made by the IEU in relation to educators. The United Voice claim was dismissed. The way the claim was formulated was effectively the Commission found it was not capable of being heard because the way they'd formulated the claim didn't fit really with the legislation or the legislative test. The IEU claim is live. The IEU claim relates to educators, and when I say educators, there is the teaching qualified educator in the childcare centre, which my high level understanding is there's a requirement for one at least in every centre. That is progressing. There's likely to be a hearing in about 4 to 6 weeks' time on that. The hearing's going to go for a month. And attached to that claim, it's both an argument that the sector is underpaid traditionally by reference to or by comparison to other more male-dominated industries, but also that the work value attached to the work is not being matched by the current wage rate. And that's why we're talking about a wage increase in that sector. So for the question, I know it hasn't gone away.
Lewis, just quickly, another question we've got here is when is your permaflexi case being heard?
Good question again. So the application's been filed in a pilot award, the social, community, healthcare, disability services sector, and any employers who are in that sector and interested in what we're doing in this place, please reach out to us. Love to hear from you because we're putting together evidence in relation to that matter. We've already had initial directions. We're looking to file evidence in approximately 3 to 4 months in support of that claim, and then likely there'll be an opportunity for the unions that have indicated their opposition to the claim to file their materials. We're probably not going to see a hearing till early next year.
Okay, thanks, Lewis. Another question here, Steve. Thank you for the question. Sorry if this has been covered and I missed it, but for matters that have potential social policy implications, could it be the case that the Fair Work Commission has delayed decisions pending the outcome of the federal election? If so, can we expect those delayed decisions may start to be released now? Now, I would never suggest the Commission would delay a decision purely on the basis of an election. But yes, you might find, Stephen, I know you're interested in the outcome from the Supported Employment Services Award decision. We will probably see that come out in the coming 6 months, maybe a little bit earlier, let's see. Yeah. Another question is, I have casual employees who do not, long-term casual employees who do not wish to convert to permanent. The 25% loading is 5% higher than the financially neutral compensation for leave compared to permanent rates. These employees want to be casual so that they can take as much leave as they like, when they like, that is, or example, parents. Can I force them to convert to permanent to avoid these issues with regards to long-term casual employees? Short answer, no, but let's talk about it a bit.
Yeah, so I think your issue, of course, your issue there is if you keep them engaged as casuals long-term, the likelihood of a claim right now, very low. The likelihood of a claim in 6 months, low. Where are you going to see the claim? The claim is if for some reason the relationship sours. You might dismiss someone for misconduct, you might make them redundant because you no longer need them. At the point of termination, one of those employees might turn around and say, actually, I'm not very happy that I'm now being let go. Doesn't look like I've got a great unfair dismissal claim. They go and see the lawyer and the lawyer says, oh, don't worry about bringing unfair dismissal, just sue for your back paid leave entitlements. You've been permanent all along. And so where we're likely to see exposure is once the relationship changes or sours, there's a termination event. And that's exactly what happened in the Skeet and Workpack case, and that's where you're exposed. There's probably only 2 things you can do to try and address that. One, try and do as much as you can to keep the arrangement reflective casual engagements. Does your contract have the right type of wording in it? Does it talk about the contract applying to each engagement and then the employment commences and finishes at the end of each engagement? Does your contract have a casual loading clause that puts you in the best possible position to recover any overpaid casual loadings? And what we're working with clients on at the moment is drafting clauses that make it clear that the amount being paid for the casual loading is not just in lieu of annual leave and personal leave, and they're the types of matters we've already seen to date, but it goes further. It says that the loading is paid on the basis that the parties have understood that the employees are casual at law, and it's only payable for that reason or on that basis. And the reason we're putting that in is if you are subject to one of these claims for back paid leave entitlements, you can then respond with quite an effective counterclaim to say, well, hang on, maybe you are permanent, maybe I owe you this leave entitlement on the one hand, but I paid you a casual loading in error. It was only payable on the basis that you're casual, and accordingly, I'm going to recover that through principles of unjust enrichment that are available through the court system. So they're the types of things we're working on contractually. The other thing is casual conversion. Why not offer it? If they reject it, that doesn't determine whether they're a casual or not, but at least it reinforces that the parties have yet again turned their mind to the issue and almost reinforced the casual arrangement. I mean, you've tried to convert them under an instrument and have failed. That didn't happen in the Scheme and Work Pack case, and had it, I don't know, Joe, is your view the court could have taken a different approach?
Look, I think, you've covered off on contracts, so if there had been a well-drafted contract in place, that would have helped. If there had been a discussion, a recorded discussion or some sort of documentation around him converting to full-time or part-time, depending on, what his hours were at the time, I think he was full-time at the time, then yeah, absolutely, there's every chance there could have been a different outcome there. And if they had that ability to set off the payments made against the payments that he was claiming, then you've got a whole range of reasons why an individual's discouraged against making a claim. You've got a contract that's well drafted. It's got the right casual characterisation in it. It's got the right set-off arrangement in it so that if you do have that claim later on, you can use those clauses to the best of their ability. It's not a 100% outcome, but it puts you in the best place. So I think the theme is make sure you've got good contracts. Make sure you give serious consideration to this issue of casual conversion. Casual conversion for many employers is your friend. And I do find the very vast majority of employers I speak to that have the casual conversion discussion with their employees and document it, those employees are not particularly willing to have the pay cut. The question we just had was, these people don't want to take the pay cut because they like getting 25% extra. And most employees don't want to take a 20% pay cut. So they say, no, we do not want that. You want that documented. You want it very clearly stated in the document. And we use standard forms that we've prepared that provide a provision for the individual to decline and sign it saying, I've declined the offer. Now, we get it. There are some industries where you just think, look, I just don't want to risk it. I can't put someone on full-time. The uncertainty of the contract I have with my principal contractors means that I don't want to get involved in that. I get it. But for the vast majority of employers, I actually think that this casual conversion process is an opportunity to provide yourself with an ability to defend it. So, Lewis, in summary, if they had the contract and they'd had the casual conversion discussion at least documented, they would have been in a much, much better place. Much better place. We do have a few more questions here. With the CFMEU, what implication will this have on EBAs for this year? Around the country, the CFMEU have not entered into negotiations for EBA due to the election. How will the result now help employers in this industry? That's really interesting because we've had a range of unions, not just around EBAs, but around award matters and other discussions in other industries, not just the CFMEU saying, oh, look, we'll see you guys in about 3 months' time. We don't want to have this discussion. And we will see them re-engage in that respect.
Well, yeah, I heard a client just yesterday say to me, the standard CFMU approach these days is 12-month terms only. I think that was because they were expecting a change of government and new laws to come in next year. I don't necessarily think that will be the standard approach anymore. And so, and you're right, it's not just the CFMEU, but absolutely there's been a deferral of bargaining in the hope of a different system. I think they're going, as we said at the beginning, I think there'll be a subdued period of activity for a few months whilst the union movement takes stock. They've all worked very hard on the current election campaign. They deserve a break. I think they're going to come out of that and then just be business as usual, back to it. And that's when I think the push for 12-month terms, I don't think that'll be as big a thing anymore. And equally, the deferring of bargaining full stop, I think they'll re-enliven bargaining, perhaps with renewed vigour.
I think so, but I think one of the last things I'd like to say as we come into the last couple of minutes, Lewis, is that I think employers need to be thinking about this being an opportunity for collaboration and perhaps the next 3 years of industrial relations, workplace relations, to be one where maybe the two halves can come together in a more constructive way under the current regime, which of course was put in place by the current industrial regime, put in place by the previous Labor government, and really try and work together in a more constructive way. The unions are not the enemy. I know there are some work sites and some employers that do. It is an enemy situation. It is very adversarial, but they're there to help their members, and by helping their members, if they help the employer run a better workplace that's safer, more profitable, and a happier place to work, then that's a good outcome for their members. So there's a real opportunity here, I think, for the coming 3 years, both for the government and for employers at large to really try and engage in a more constructive way. views, Lewis?
Oh, absolutely. And I think we always talk about the way in which you can improve your workforce culture. It's a big deal for our CEO. He does a lot of training in relation to frontline leadership and cultural engagement. And improving productivity at large is not done by just black and white rules. It's about having a cultural shift, and part of that has to be a level of engagement and cooperation so that the union movement and their members feel like they are participating in decisions at the workplace, they are being heard, even if the outcome isn't one that they like at the end of the day. We don't always get outcomes we like. But I couldn't commend that approach more.
Well, that brings us to the end, and thank you all for tuning in. The recording will be made available as it normally is. There's a range of things that we can help you with if you ever are interested in Lewis or I or one of our team, a very large team up and down the Australian East Coast, helping you out. Then our numbers are easily available and our website's easily accessible. We do these webcasts about once a month. We run training courses. We do training courses in Melbourne, Sydney, Brisbane, Newcastle, and a range of regional areas when we have clients who are interested in having us in those regional areas. A couple of times a year down in the Murray Riverina, up in the Northern Rivers, where we have planes, we'll travel. So we have been known to travel to other states. We regularly head over to South Australia as well. And we have all the usual box and dice that you need. So feel free to reach out to us if you ever need a hand in this space. But let's wait and see what happens in this coming 3 years. It's going to be an exciting time. Thank you.